Following the exploration of commercial lease types and their implications for landlords and tenants, it is equally important to understand the tools and instruments used to express interest and initiate negotiations in commercial property transactions. Unlike residential real estate, where standardized contracts and consumer protections are heavily regulated under Arizona law, commercial transactions are more flexible and often involve customized agreements that reflect complex financial and legal considerations. The instruments used in these transactions not only communicate intent, but also establish the foundation for enforceable contracts under Arizona law, particularly under ARS BCRA 44-101, Arizona's version of the Statute of Frauds, which requires agreements concerning the sale of real estate to be in writing to be legally enforceable. In Arizona, commercial real estate practice, the most common instruments used to express interest and make offers include the letter of intent, LOI, the offer to purchase, the option agreement, and the purchase and sale agreement, PSA. Each instrument serves a unique role in defining the level of commitment between the parties and outlining the terms of the negotiation process. The LOI will be used back and forth and redline for any changes in terms. Once all are agreeable, then the contract to lease or purchase is drawn up. A letter of intent, LOI, is often the first step in a commercial real estate transaction. It expresses a party's interest in pursuing a purchase, lease, or development agreement, but generally does not create a legally binding obligation to close the transaction. Instead, it serves as a roadmap for further negotiation by identifying key terms such as purchase price, deposit amount, due diligence period, financing contingencies, and closing timelines. Under Arizona law, an LOI may become partially binding if it includes language obligating the parties to negotiate in good faith or to maintain confidentiality during the process. The Arizona Court of Appeals addressed this in AROC Construction Co. v. Indian Construction Services, 1991, emphasizing that the enforceability of an LOI depends on the intent of the parties as reflected by the wording of the document. For example, if an LOI states that this document is not intended to be binding, it is generally treated as non-binding. However, provisions regarding exclusivity, confidentiality, or good faith negotiation may still be enforceable. The offer to purchase is a more formal expression of interest and represents the buyer's proposal to acquire a property on specific terms. Once signed by both parties, this offer becomes a binding purchase and sale agreement. The offer typically includes essential elements required under Arizona law: identification of the property, the parties, the purchase price, and the closing date. In commercial practice, the offer is often accompanied by earnest money, which demonstrates the buyer's commitment and is held in escrow. Earnest money in commercial deals can range from 1% to 5% of the purchase price and may be refundable during the due diligence period or become non-refundable after contingencies are satisfied. An option agreement is another important instrument that grants the buyer the right, but not the obligation, to purchase a property within a specified period at an agreed-upon price. This tool is commonly used in commercial development projects, such as retail centers or industrial parks, where zoning, permitting, or feasibility studies must be completed before the buyer commits to purchase. For instance, a developer seeking to construct a logistics warehouse in Maricopa County may enter into an option agreement with the landowner, securing the right to buy the property within 12 months while conducting environmental and infrastructure evaluations. Option contracts are also subject to the Statute of Frauds, codified under ARS paragraph 44-101, which requires certain contracts, including those for interest in real property, to be in writing to be enforceable. Option contracts in Arizona. While Arizona recognizes the enforceability of option contracts provided there is consideration, an option fee. This enforceability is rooted in general contract law and judicial precedent. AROC Construction Co. v. Indian Construction Services, 1993. While not specifically an LOI case, it is frequently cited alongside LOI disputes. It established that an agreement can be enforceable even if essential terms are missing, provided the parties' intent to contract can be reasonably determined through their actions or trade custom. A 155 Arizona 417, 747 P2D, 1169, Arizona C. App, 1987. The plaintiffs, Whaler, entered into a real estate option contract with the defendants, Yancey, to purchase property. The contract required the payment of an option fee in exchange for the right to purchase the property within a specified time. After paying the fee, a dispute arose about whether the option was enforceable. Whether an option contract for the purchase of real property is enforceable when consideration, an option fee, has been paid, even if the option has not yet been exercised. The Arizona Court of Appeals held that the option contract was enforceable because the plaintiffs had provided valid consideration, the option fee. The court confirmed that consideration is sufficient to support an option contract, and the optionee has a legally protected right to exercise the option within the agreed timeframe. Consideration is essential for enforceability of an option contract. A real estate option does not require immediate exercise to be valid. The payment of the option fee creates a binding right for the optionee. Finally, the purchase and sale agreement, PSA, is the central instrument that formalizes the transaction. It outlines all material terms, representations, warranties, and contingencies agreed upon by the buyer and seller. The PSA typically addresses title and survey requirements, due diligence timelines, financing conditions, inspection rights, and closing procedures. Because commercial PSAs are not standardized by the Arizona Association of Realtors, as residential contracts are, they are usually drafted by attorneys to reflect the specific complexities of the transaction. Licensees must adhere to Article 26 of the Arizona Constitution, which permits real estate licensees to draft contractual documents only when they represent one of the parties in the transaction, and only in connection with property they are licensed to handle. In commercial transactions, supporting instruments such as letters of credit, escrow instructions, and memorandums of understanding, MOUs, may also play key roles. For example, a buyer may provide a letter of credit in lieu of a cash deposit to demonstrate financial capability, or parties may execute an MOU outlining collaborative development terms before entering a formal contract. Regardless of the instrument used, all written agreements must satisfy the statute of frauds to be enforceable in Arizona courts. Review summary. In Arizona, commercial real estate, expressing interest and formalizing offers requires the use of specific legal instruments that align with the transaction's complexity. The letter of intent establishes preliminary terms and expectations. The offer to purchase conveys formal intent. The option agreement provides flexibility for due diligence and development planning, and the purchase and sale agreement finalizes all binding terms. Real estate licensees must understand the enforceability of each instrument, the legal obligations created by written versus non-binding agreements, and their professional limitations under the Arizona Constitution and administrative rules. Discussion prompts. Why is a letter of intent often used in commercial real estate negotiations before a purchase and sale agreement? Answer. It outlines preliminary terms and expectations without immediately creating a binding contract, allowing both parties to evaluate feasibility and negotiate major deal points. What distinguishes an option agreement from a purchase agreement in commercial real estate? Answer. An option agreement gives the buyer the right, but not the obligation, to purchase a property within a defined timeframe, while a purchase agreement obligates both parties once executed. Under what condition can a real estate licensee draft a contract in Arizona? Answer. Under Article 26 of the Arizona Constitution, only when the licensee represents a party to the transaction and the document pertains to property within their licensure authority. Closing remarks. The instruments used to express interest and make offers in commercial real estate serve as the backbone of every transaction. Each document, from a simple letter of intent to a fully executed purchase agreement, carries legal and financial implications that must be understood by all parties involved. Arizona's legal framework ensures that such documents are created with transparency, intent, and professional competence. By mastering these tools, real estate professionals enhance their ability to guide clients through complex negotiations with clarity and precision, while ensuring compliance with statutory and constitutional requirements. Supporting sources and key case law. ARS R 44-01. Statute of Frauds, requiring real estate agreements to be in writing. ARS Par 44-101. Consideration requirement for contracts. Arizona Common Law Contract Principles. Article 26. Arizona Constitution. Authority of real estate licensees to draft documents. AROC Construction Co-ver Indian Construction Services. 1993. While not specifically an LOI case, it is frequently cited alongside LOI disputes. It established that an agreement can be enforceable even if essential terms are missing, provided the parties' intent to contract can be reasonably determined through their actions or trade custom. Wheeler v. Yancey, 155 Rs and 417, 747 P2D, 1169, Arizarikiki Apsius, 1987.